Mr. Carter, your client asserted a cross-claim. Are you going to deal with that in your main argument?
Yes, Your Honor, my plan was to address my reply and then proceed with my cross appeal, but obviously I can wait on that if the court wants to hear the appellant's reply to my.
You want to do it all in your 20 minutes and then
That's what I had planned.
then we can just we'll have the reply, the rebuttal that will address everything that would like to be addressed. Is that okay?
That's what I thought would
Okay.
happen.
Very good. Mr. McHale, you're up.
And I'd like 3 minutes for rebuttal, please.
Very well.
So good morning. May it please the court. Kevin McHale on behalf of the appellant and cross appellee Tailored Interiors. Your Honors, this appeal, it's about 3 issues. They're related to a construction contract to renovate a condominium unit. Now, the first issue is regards of the purchase of an additional matching granite slab. Now, on their surface, these issues, they may seem mundane to my clients who have poured their life into this company for 25 years. This renovation project, it's much more than that. It's about their name, their reputation, their word. Now, I want to just briefly go through the sequence of events that led to this because they're pertinent to the issues. The remodeling of the contract, the contract was entered into in May of 2019. In June, the product selections were finalized and construction started in July of 2019. Now, that was planned to coincide with the Condominium Association's Common Element Replacement Project. So after the association finished its work, they would hand over the unit to the owner's contractor for remodeling. And that work continued through October of 2019. Now,
and you had to come back and they had to come back and do it again for some portion.
In an unanticipated comeback, correct.
So
now,
your theory is that it's the kind of association that caused the problems with
it's not, we, you know, as the expert said, and as even counsel said, we don't know who caused the problem. We know that at some point a problem was caused, but the issue is, did Tailored Interiors cause this problem? Because after passing inspection, the unit was turned over to, and it's a newly renovated unit, turned over to the owner. We presented at trial the time-stamped photographs that depict the mint condition of this unit. And then after being in the unit for about a month and a half, the owner then gave a final punch-out list or a closeout punch list. You know, those items were completed the following week, followed by a 5-star online glowing review of Tailored Interiors work. Now,
is there any testimony? Let's stick on the cabinet. Is there any testimony about the possibility or probability that the chipping and the could have taken time to develop? You know, if the undercoating is not applied properly, then the next layer of paint isn't going to stick. You know, that sort of stuff. That the kind of thing that would take some time to present itself.
There was no testimony about what. Well, let me just say this: is that the Mr. Firestein presented testimony that of a witness, Charlie Scott, and now he testified that the gouges, the marks, the scrapes that in his best guess, and that those were the terms he used, that his best guess is that those reasons were related to Tailored Interiors. Now, he confirmed he was not present at any time following turnover by Tailored Interiors, and then the more than year that passed when these alleged blemishes and marks were reported. Now, I say alleged, I mean, whether or not they were caused by a lack of care, improper use, or improper maintenance by others. All of that happened after the project had been turned over by Tailored Interiors and then turned over to the association's contractor, because in the summer of 2020, the association's contractor had to come in, take possession of the unit. The unit owner had to vacate. And as Mr. Charlie Scott was uncertain at trial as to what caused that, counsel said, "Hey, nobody can say what caused these gouges, these nicks." But despite that, the trial court found that Tailored Interiors had breached the contract after they had turned it over. Now, the photographs at turnover show that there is this, and their timestamp photographs presented at trial show that they depict the condition of those cabinets at that time. The owner then gave this final closeout punch list. Those items were completed the following week. None of this is in dispute. That was followed by a 5-star review of the work.
Can I ask you to shift your focus a little bit?
Yeah.
One of to the legal issues that we have to look at here. It strikes me that one of the main issues that's been fleshed out in the briefing was the accord and satisfaction defense.
Mm-hmm. Yes.
And your opponent argues that there's just the email, and the question of accord and satisfaction includes consideration of intent of both parties, and the email being a unilateral act, that the trial court resolved the intent question as a matter of fact, and that there's substantial competent evidence to support that conclusion. So what is, if that's the case, then we can't disturb the judgment with respect to that defense. Tell me what your path around your opponent's argument on accord and satisfaction is.
Yes, I think that gets to the scope of what the owner intended to settle. Now, he submitted on October 25th of 2020 an email proposal stating, and it's entitled Original Cabinet Issue and Unused Granite Slab. He proposed to settle the dispute pursuant to certain terms. Now, those terms were that Tailored Interiors must release the slab that it held in stock, the stock where it held all of its granite at Sunmat Granite. Tailored Interiors must return the one door that they were holding as they tried to match the paint color, which was as a courtesy. And in exchange, he would then submit payment in full and final resolution of a compromised amount. Now, that compromised amount that was negotiated down to $794 and change. That had been compromised from over $5,000. But that scope was dictated by the owner's own emails where he was threatening suit. He was saying that he was going to file this lawsuit about these issues, the granite slab and the cabinet paint. These were the issues he was threatening to sue over. So the record evidence and presented at trial show that he was threatening to file a suit over these particular issues, cabinet paint and granite slab, and there was nothing at trial presented that corroborate this limited scope. That I didn't mean to. I only meant to resolve the bill that Tailored Interiors claimed that I owed.
Has there been, if there's an accord and satisfaction, has there been full compliance? I recall something in the brief suggesting that the slab has never been released.
Yes, and so the parties certainly performed. Now, the mutual performance was that effectuated the settlement was that Tailored Interiors would release the slab, and to answer that question, you have to look to the contract. What did the contract for the slab entail? Well, it entailed purchasing a slab to purchase and hold only. It was an insurance policy in case when this unanticipated work came in, that there was damage to the newly installed slabs. So yes, there was certainly performance.
Well, I'm troubled by that. I mean, the guy paid for an extra slab. He didn't need it because the installation went fine, but it doesn't seem possible your client can hold the money and hold the slab.
Well, and that's what they didn't do.
Well, how come he doesn't have it yet?
Yeah, and that gets to what the evidence showed that at trial that Mr. Firestein, the owner of the unit, never tried to pick up the slab. So
He called over there. He showed up over there.
He did.
Yeah.
He called over there, and what he discussed with them was having them buy the slab back from them or selling the slab for him. But what he never tried to do, what there was no evidence of, was that he did not try to pick up the slab. He never tried to take possession of it.
Well,
And
he
that-
was told that he was told they needed a release from your client.
which was then provided, and that evidence was presented at trial. Written authorization. He said that he spoke with Sunmac Granite, the party holding that slab where all of Tailored Interiors slabs are held, and that he spoke with them about either selling the slab for him or buying the slab from him. Now, Tailored Interiors, they weren't required to sell it for him. They weren't required to buy it back from him, just as they were not required to deliver it to him. The owner, Mr. Firestein, he was entitled to take possession of that slab, that heavy, cumbersome slab, to show up with a crew of men or women and transport it to a location of his choosing. That is what he was entitled to do. He never attempted to do that. Now, certainly at trial, there was no suggestion that Tailored Interiors ever interfered with him, prevented him from doing that. We know he never tried to go and pick it up because he testified he went to Sunmac, he confirmed it was there, he talked to them about buying it back or selling it from him, but what he did not do was ever try to pick it up, ever try to take possession of it. That is what he was entitled to do under the contract. It was to purchase and hold only. The contract said no installation, no delivery. It was only an insurance policy in the case of damage. The slabs were not damaged during this unanticipated work. And so what he was entitled to do is to come pick it up. He never tried to do that. But the trial court found that because Firestein testified that he did not receive his slab and he had asked for a refund of a non-refundable slab, but did not receive that refund. And for those reasons that the court found that a refund was appropriate. Now, to be clear, we're not contending that he's not entitled to his extra slab. Of course he is. Absolutely. He's entitled to take possession of it, to come pick it up, and then do with it as he sees fit. Keep it, sell it, that's up to him. He discussed with the company about selling it, and they tried to find a second slab for him because selling 2 slabs was easier than selling 1 slab. But that was it. That was the extent of what he attempted. So for those reasons, a refund from Tailored Interiors on this non-refundable slab, there was no contractual obligation that Tailored Interiors failed to perform. And as we set forth in our brief, to prevail on a breach of contract claim, the defendant or the plaintiff must prove that it was the defendant's non-performance that goes to the essence of the contract that caused the plaintiff's damages. Now, we refer to the court to the 1993 first DCA case of Prestige Development Group versus Russell to stand for that proposition. Tailored Interiors was contracted to purchase and hold the slab, which they did safely with the rest of their stock at Sunmac Granite. There was no duty, contractual or otherwise, that Tailored Interiors failed to perform that caused the owner's damages. He was not entitled to have that slab delivered for him, to dropped off for him, to be installed for him. That was not the benefit of the bargain. And because there was no competent, substantial evidence presented at trial to sustain the finding that Tailored Interiors breached the contract, the court should reverse the trial court's finding that Tailored Interiors breached as to that additional granite slab purchased as an insurance policy that ultimately was not needed. Mr. Firestein admitted, hey, I own the slab, it's mine. I'll handle selling it. I'll be the one that sells it. Get you out of the middle. I don't want you as the middleman. Let's get you out of here. But what he did not do was ever attempt to take possession of it. So he then proposes to settle this issue. Now, in his own words, that was to settle this ongoing matter. He identified the dispute. It was the granite slab and it was the alleged cabinet paint issues. Now, the unit was turned over back in October of 2019. He then occupied the unit, the owner did, for 7 months. He was forced to vacate again, but that was the summer of 2020. There was never any complaints, no issues, no alleged defects. There was nothing. At the trial, Mr. Phil Forrester with Tailored Interiors testified that upon the inspection of the unit after the association's rework, he observed the damages to Tailored Interiors' work, damages to the cabinets, damages to the walls, the floorboards, and it was throughout the unit. And these were reflected in the photographs that were presented at trial. To be clear, the condition of the work of Tailored Interiors' work at turnover in October 2019 was starkly different than in after the association's turnover in July of 2020. Now, the work that the association did again was unanticipated. When Tailored Interiors came in, there were problems, there were defects, there were gouges. I shouldn't say defects. There were gouges and scratches, and they agreed as a courtesy, hey, we'll touch it up. There were scrapes that they felt bad for them. They felt sorry for the fact that this newly renovated unit, they've now come in here and do this work. But that gets to what then occurred was Mr. Firestein, the owner, he submitted a proposal by email to settle the cabinet issue and the granite issue. He proposed on those terms pursuant to an email that is in evidence on October 25th of 2020. And he demanded that Tailored Interiors release the granite slab that was held in stock, which then happened, return the door that Tailored Interiors was holding to try to match paint, again, as a courtesy. And in exchange, he would then submit payment, which was a compromised amount. And Tailored Interiors then agreed to accept that amount to resolve the dispute and avoid litigation.
Mr. McHale, excuse me, you're into your rebuttal time, but use your time as you wish.
Yeah, thank you, Your Honors. So the trial court did not take into consideration the competent substantial evidence of estoppel, of waiver, of accord and satisfaction. And so this court should reverse as to the findings that Tailored Interiors breached the contract with respect to the additional granite slab and the alleged cabinet defects that Tailored Interiors was not in possession, custody, and control over.
Thank you, sir. Mr. Carter, you're up.
Good morning, Your Honor, and to the court, may it please the court, I am Scott Carter. I'm sorry, you just looked up. Can you hear me all right, Your Honor?
I can.
Okay, I'm sorry.
Help me solve the case. Help me solve the case of the missing slab.
Okay, I'm happy to assist.
Why did he go pick it up?
it remains missing. Mr. Firestein testified that he did go to SunMac, and that he talked to the person at SunMac, and the person looked for the slab and said, I need to get approval from Tailored Interiors to do anything with this. And additional time passed. Mr. Firestein, I believe, testified that he didn't hear anything. He called SunMac back to find out what's going on with my slab, and they did not get back to him again after that. And I believe he emailed them as well and asked them about that, and never heard anything further from SunMac. Now, to address the SunMac issue, Mr. Firestein has no relationship to SunMac. It was all, they are subcontractors, presumably, of Tailored Interior. And Tailored said, go to SunMac, not our problem. But his contract was with Tailored Interiors. His contract wasn't with SunMac. He tried to contact SunMac. He said he got no resolution or a positive response from them. They said, I believe they said at one point, I think we have a second one and we'll get back to you. And they never did. And, so he went back to Tailored and said, they're not providing me with any information on this. I can't get them. He went down there to get it and he couldn't get it. He tried. And, that was certainly a reasonable attempt for him to put an end to this problem, but there was no cooperation at the other end. And frankly, he didn't know what to do. At that point, SunMac is down in Fort Myers. We're in Sarasota. It is an hour-and-a-half drive. So it's not, like it's just next door. But really, I do not believe the burden was on him to do that. The contract says Tailored Interiors is going to purchase and hold this slab for him. Tailored Interiors didn't hold any slab for him. They said, go to Fort Myers and go find it yourself. And there's no evidence that Tailored did anything to assist that until, I think it was November of 2020. There's an email from Tailored Interiors to SunMac, and that's it. So that's where it left off, Your Honor. Now, the granite slab clearly was paid for. The trial court's findings, which I think is really what's being attacked here, the findings are all correct. There's no dispute as to the fact that this was bought provisionally, that it wasn't needed. And the point wasn't whether the slab was refundable, because Mr. Firestein didn't ask for a refund. He tried to recover the slab and was trying to locate the slab. How does he get it when it's not at Tailored Interiors, who said they're going to hold it? They provided insufficient assistance to allow him to recover it. Again, Tailored's position is, sorry, it's not refundable, but he paid for it. He didn't get it. Nobody produced it for him and said, here it is, come get it. And the burden wasn't on him to sleep over at SunMac till they give it back to him. He didn't have any contractual relationship. You've seen an argument that his remedy was to replevin the slab from SunMac, but he didn't have any proof or evidence that SunMac even had it or that it was his slab. If SunMac got back to him and said, yes, we've got it, here it is, it would have been different, but that didn't happen. The court correctly found that Tailored Interiors did not hold the slab. as it was required to do under the contract. And it awarded the recovery based on that for its breach of contract, and it's fairly simple. And I believe that's the extent of the issue with respect to the granite slab. There is no error. The court findings of fact were correct. And as far as the other defensive issues, the legal defensive issues raised, those were really raised, as I see it, in the context of the cabinets, which is a second issue. And that is the argument by the appellant is that there is an accord and satisfaction of all issues on these cabinets, and the cabinets are not addressed in this email that appellant relies on. Mr. Firestein wrote this email late. He testified at trial about his email that they're alleging to be an accord and satisfaction. And his testimony was that this wasn't my attempt to resolve all of the issues with the cabinets. They're not even addressed in this. This talks about the amount owed for the work. There was a balance owing, and he was trying to work out how much is owed. And as the court correctly pointed out, one of the terms was provide a written release, so SUNMAC will release a slab of granite I purchased. They believe they have it, but since it's been several months, they need to confirm it to me. They never did that, and that never happened. And it says, if in fact SUNMAC has my slab of granite, I will give you the check. Well, he went ahead and gave him the check, and SUNMAC never produced the slab of granite.
Let me ask you this. Why would he, the final payment was like $700, $800, something like that. Why would he release $700 or $800 when he's got this problem with the cabinets? Even $700, $800 is some leverage over against Tailored.
I think his concern, I believe he testified to this at trial, his concern was that he would start being charged interest and he would compound the matter, and he wanted to put the payment issue to rest and have the warranty claim, which is what we pursued, is a warranty claim based on the fact that these cabinets peeled, scraped, chipped, and had basically a soft paint to them that was improperly applied, as testified by the experts at trial, both Charlie Scott and the cabinet refinishing expert, who said there was a problem. They couldn't identify, it's very difficult to identify, why is this failing? What's wrong here? Was the wood not prepared properly? Was the, paint finish not prepared, applied properly? What was the problem? They said, look, there's just a problem with the process, with the paint. And that's why the doors had to be replaced rather than repaired or somehow repainted. As far as why Mr. Firestein did what he did, like I said, he thought that he wanted to be in the right on this and not have any issues hanging out as far as him owing anything in order to get the relief that he felt he was entitled to. And he continued, there's been this argument that somehow these problems magically appeared after the iron pipes were replaced by the condominium association, but that's contrary to the evidence. The court even points out in the final judgment that there was testimony that Mrs. Firestein was painting, doing some touch-up work as the unit was being turned over to the Firesteins initially, and that there were problems from the start. And the testimony on that from the plaintiff was that Tailored Interiors said they'd take care of everything after the iron pipes were replaced. we'll fix these things when we come back to do the rest of the work. And that's why it remained until after the iron pipes were done. Now, contrary to the appellant's position, there was no testimony and there was no evidence that the appearance was starkly different before and after the pipes were replaced. That the evidence was that the pipe replacement was limited to the bathrooms. It did not occur in the kitchen, and the kitchens where these cabinets were located. And that's why the experts that testified on the point both testified, they weren't there. They can't absolutely prove that they weren't damaged by some outside source, but they said the problems with the application of the paint. But the problems are not consistent with people bumping into them because they're all over the place. The court can see that by looking at the photographs that show where these chips and scratches are. And it's evident it was evident at trial, and the witnesses also testified, we're not going to get these 105 different problems from the pipe replacement, from somebody banging it with a stray pipe. And that was not, obviously it's an opinion because nobody was there 365 days of the year to testify. This absolutely didn't happen, but it was not consistent with that sort of damage. The court was correct in finding that the cabinets were not of good and workmanlike condition as required by the contract. And the final judgment notes that the facts that included the 66 doors and drawers that were replaced, were not shown to have been caused by the work done by the association. And that brings me to the third issue. There's an overriding issue about the lateness of the notification, and the contract warranty language specifically states that the products are warranted to be in the condition described in this proposal for a period of 1 year after completion of the work. These complaints all arose within 1 year of the completion of the work. Now, that brings me to the third point, which is my cross appeal, and that's the issue on the window blinds. And on the window blinds, it clearly, I don't think anybody disputes, the original contract that was entered in evidence calls for these gray window blinds, and those are not the window blinds that were installed. It was a different brand, and they were a different color. And there was testimony from my client that there was discussion about this early on, and that the Tailored Interior said, Mrs. Little, my client's significant other, changed it from gray to beige. And that violated the contract. If that had happened, any changes to the contract had to be in writing, signed by both parties. The contract further says the party is Don Firestein and no one else. He's the one given sole authority over this contract on behalf of the owner. He never made the change. They said Jane Little made the change. There's no document signed by the parties making this change. And this complaint, the one that the court points to, is in November of 2020, where the email that is sent by my client addresses the issue of the window blinds. And recall, the first turnover occurred in November of 2019. And then there was the hiatus from December till May of from 19 to 20, where no work was allowed at the condominium. And then Tailored continued its work in sometime the summer of 2020. But even if you go to the November date, where the initial work was stopped, his written email on the point, this plaintiff's exhibit Q at trial, was November 10th. So it is within the year. And then, the contract is our position. I think it's pretty clear. The contract describes the work as being everything that's in the contract. That includes the window blinds.
Is it
The work
conceivable that a
wasn't-
trial court could have concluded, there's a lot of nuances with the slab and with the cabinets, but from day one that they're gray and not white. And you sit on it for a year.
Well, I disagree that they sat on it for a year. The testimony was that they brought it to their attention, and Mrs. Forestier said that was your significant other, Jane Little, changed it. And Mr. Firestein testified, I knew that wasn't correct because I was with her and it didn't happen. So what's the point? Why am I going to put this in writing? I mean, I'm seeing these people on a regular basis. I'm not going to go put something in writing when they're saying, no, you changed it, so that was the reason he didn't do anything further, but he did put it in writing as kind of a recap in November of 2020, when he mentions in that writing, we've talked about this and you're saying she changed it. She didn't. I mean, what's there to say? And that was what he testified, similar to what he testified to at trial on that point. That's why there wasn't writings. He said, what's the point?
And there, as I understand, Mr. Carter, there's a quality question about these blinds.
They wanted a different brand than the brand that was installed. And the testimony was that the brand that was installed is not mildew resistant and UV resistant. They received Norman, the other brand, I can't remember the name of the other brand, Suntech or something, was what they wanted. And so they got a different brand as well. So I believe that the issue on the blinds is a matter of law. It's a question of law. It's a legal issue. The other two issues are fact issues that the appellant has a dispute with. But on the issue with respect to the blinds, again, I think it's a matter of the contract dictating that the blinds would be as per the specifications. They were not, and that was warranted for a year. And
What's the client want? Does he want a refund or does he want new blinds?
Well, either. At trial, we weren't asking for specific performance. We were asking for the money damages for the value of the blinds. And the court, in its final judgment, notes the value of the blinds was $6,800. And so that was proven, but the court did not award that. That's what was paid for the blinds that were not received. So for those reasons, we request that the court reverse the trial court's decision with respect to the window blinds, because I think the contract clearly provided that they were within the time and had the right to request what was specified in the proposal, that the other issues, the really legal issues, there was no accord and satisfaction. The other issues are really factual issues having to do with the granite slab and the cabinets. And we would request the court to uphold the trial court's decision with respect to both of those issues.
Very well. Thank you, Mr. Carter. Mr. McHale, 3 minutes.
Yes, thank you, Your Honor. First, with respect to Lisa Forestier and the comment that she was touching up paint on the cabinets. She was touching up paint, as she testified, for the photo shoot. It was not to cover up gouges and marks and scratches that appeared after the association's unanticipated rework. Now, with respect to what Mr. Charlie Scott testified. At trial, he testified that he reviewed the photos at turnover from Tailored Interiors in October 2019 and did not see these marks, these scrapes, these gouges that subsequently appeared after turning over the unit to the association's contractor. He said, we don't know what it is. It may be paint application, but those scrapes and gouges were not previously there. Now, as to the blinds, the cost of the blinds, the Norman blinds, that was more expensive than the blinds that ultimately were ordered. Now, what the Firestein is attempting to do is this form over substance argument that the owner's partner, Miss Jane Little, did not have authority to make these decisions on the project. The court properly rejected that. The evidence at trial confirmed that Firestein and his partner, they held themselves out as a married couple. The contract was in the name of Mr. and Mrs. Firestein. There was never any objection, no correction to that. They used the same last name, Don and Jane Firestein. His partner routinely made decisions on finishes, selections, colors during the course of the project. And just like with the granite and the cabinet issues, the motorized blinds, they weren't included on the final punch list, the closeout punch list. If there's these issues and they extend back to October of 2019, why weren't they included? It defies logic, but there was never any objection. There was never any complaint about the blinds, the cabinet paint at any time. And importantly, and I think what the court glommed onto was there was Tailored Interiors contemporaneous notes at the time. On June 3rd of 2019 at 9 a.m., Ms. Forestier prepared a contemporaneous note stating that Jane wants the roller shades changed to Norman A400, chalk beige, not the original Suntex 95. The Norman shades are of higher quality. And then Lisa Forrester added, if there's a price upgrade, which there was, no charge. The issue as to the blinds, there was the substantial evidence presented at trial. There was no breach of contract. There was a course of conduct. We're not going to allow this form over substance. And so for that, the decision of the trial court should be upheld. Now,
We're
as
out of time, Mr. McHale.
thank
Please
you.
wrap it up.
Yes, as to the scope of the accord and satisfaction is in Mr. Firestein's own words. It was to resolve the cabinet paint issues and the granite slab issues. 2 emails, October 25th and November 6th, ultimately was accepted by Tailored Interiors, and they accepted that compromised amount that he tendered. Thank you.
Thank you, Mr. McHale. Mr. Carter, you want 30 seconds to reply to the argument about the blinds? Or are you good?
I'm sorry, I think I'm gonna have to say I'm good because I really don't recall
Okay.
the point.
Very
made.
good. Thank you, Mr. Carter. Thank you, Mr.
Rest
McHale.
in-
Stay
Thank you,
safe
Ernest.
and stay dry.
Thank you.
You can push the button and exit our virtual courtroom.
Thank you.